justify certain kinds of regulations, but the baseline is always the right established in the text. And there'll be tough questions as the arguments revealed about what the historical practice shows, but the default or baseline is the text. Right.
That's absolutely right, Justice Kavanaugh, and of course that's no different from something like the First Amendment, where of course you start with the text, and it's very emphatic text, no law abridging speech, but then you look to history and tradition just to realize, oh, well, there's a long tradition of treating defamation and libel different going back to the framing, so you use that history to inform the text, but the focus is on the text.
And last question, following up on Justice Gorsuch's question, as he points out, some courts have used intermediate scrutiny or strict scrutiny. Those are balancing tests. I think Professor Alcia's amicus brief is very helpful on that. There's well-developed law in other areas, but it'll be no surprise to you. I have concern that would just be a balancing test that would make it a policy judgment, basically, for the courts. And I don't know why we would. You say you'd be okay with that, but I'm not sure why we would smuggle all that into here, and then it would just be a policy judgment that would be unanchored from the historical practice.
So, Justice Kavanaugh, 2 points just in response to that. One, as you articulate the concerns with interesting balancing, that might be a reason that if you're going to go with the level of scrutiny's approach, you would go to strict scrutiny, where I just think there's less play in the joints. But the second...
but what's a compelling interest? Do you have a there's a lot of play in the joints in some of the other areas, so I don't know that you want to open that door.
And the second point I was going to make, though, Justice Kavanaugh, which is maybe more consonant with the thrust of the question, is, whatever was the case in Heller, where I sort of read the majority opinion as actually already rejecting interesting balancing, but whatever was the case in Heller, we now have this 13 years of experience with lower courts applying the test. And in our view, they've made a muddle of it, and it's probably the experience of the last 13 years is probably a very good reason to prefer a text, history, and tradition approach to this area of the law.
Thank you.
Justice Barrett?
Mr. Clement, I have one question. So a couple times in response to my question about Times Square and New Year's Eve, and then just now as well to Justice Kavanaugh, you made reference to the First Amendment. And obviously, a lot of the questions that have been asked have been focused on how can the state fairly regulate? Because everybody agrees there have to be some regulations, and it might not be the case that we can always find exact historical analogs. So returning to the First Amendment, in response to me, you said, well, that might be analogous to a time, place, and manner restriction. So do you think the First Amendment and the edifices that we have structured around it would be a helpful place to look? Is that what you're suggesting?
Well, I'm suggesting that there is a lot of useful teaching in the First Amendment. I'm not sure I'm suggesting you should just take sort of doctrines lock, stock, and barrel from the First Amendment. But, going back, well over 100 years to like Robertson, when the court was just talking in dictum about the First and the Second Amendment, it drew the analogy between allowing some restrictions on the Second Amendment and, in the First Amendment context, the First Amendment being consistent with libel and defamation. As I suggested to the Chief Justice, I think the way you think about a non-public forum and why that's different from First Amendment purposes from a park, I think could be useful in some of these contexts. If you focus on the nature of the location, you might say this is inappropriate for weapons, but in the same way as in the First Amendment, you just don't get to say, well, we're going to make it a non-public forum by saying no First Amendment activity there. You can't just take a location and say we're going to make this a sensitive place by saying no Second Amendment activity there. So those kind of analogies, and lastly, the analogy being you look at a law that says no concealed carry in a particular place on one night of the year quite differently from a law like this that says there's really no way for a typical New Yorker to conceal carry anywhere that the general public is allowed to go. Those under the First Amendment, those are radically different laws, and I think under the Second Amendment, those are radically different laws.
Thank you.
Thank you, counsel. General Underwood.
Mr. Chief Justice, and may it please the court, for centuries, English and American law have imposed limits on carrying firearms in public in the interest of public safety. The history runs from the 14th century Statute of Northampton, which prohibited carrying arms in fairs and markets and other public gathering places, to similar laws adopted by half of the American colonies and states in the founding period, to later state laws that relaxed restrictions for people who had a concrete need for armed self-defense. Starting as early as the early 1800s, states began taking different approaches to regulating firearm carrying in public. Some states provided that a person who carried firearms in public without reasonable cause could be arrested and required to post a bond. Other states made it a misdemeanor to carry a handgun without reasonable grounds to fear an attack. Other states and territories banned carrying handguns in towns and cities altogether, or restricted it to situations of immediate threat. And in the early 1900s, many states made good cause a requirement for a license to carry a concealed handgun, while also prohibiting, in some cases, the open carrying of handguns. In total, from the founding era through the 20th century, at least 20 states have at one time or another either prohibited all carrying of handguns in populous areas or limited it to those with good cause. New York's law fits well within that tradition of regulating public carry. It makes a carry license available to any person, not disqualified, who has a non-speculative reason to carry a handgun for self-defense. New York is not an outlier in the extent to which the state restricts the ability to carry firearms in public, and it's not an outlier in asking a license applicant to show good cause for a carry license. Many ordinary people have received carry licenses in New York State. If the court has questions about how the law works in practice, it should remand for fact-finding. And if the court finds the history ambiguous, it should review the law under intermediate scrutiny and uphold it.
General Underwood, you seem to rely a bit on the density of the population. You say, I think, that states like New York have high-density areas. And the implicit in that is that the more rural an area is, the more unnecessary a strict rule is. So when you suggest that, how rural does the area have to be before your restrictions shouldn't apply?
Well, I think the way the New York statute works is consistent with a reasonable rule, which is that there's not a cutoff, there's not a number at which things change, but that licenses, unrestricted licenses, are much more readily available in less densely populated upstate counties than they are in dense metropolitan areas. And that is a virtue of the system of having licenses handled by licensing officers who are part of the local community and who take the density of population into account, as well as the many other factors.
Well, Mr. Nash lives in quite a low density area. That's why I'm interested in where your cutoff is. It's one thing to talk about Manhattan or NYU's campus. It's another to talk about rural upstate New York.
He actually lives in what I would call an intermediate area. He lives in Rensselaer County, which is not that far from Albany, and it contains the city of Troy and a university and a downtown shopping district, but it also contains substantial rural areas. And that is precisely what the licensing officer here was taking into account when he made the differentiation between, don't take it to the shopping mall, don't take it downtown, but you can take it in the sort of backcountry areas.
Thank you.
General, you mentioned that the gun is, I guess permits are more readily available in a less populated area.
Unrestricted permits.
Unrestricted permits
are more readily available in less populated areas, yes.
Now, Heller relied on the right to defense as a basis for its reading of the Second Amendment, or that was its reading. Now, I would think that arises in more populated areas. you're out in the woods, it's pretty unlikely that you're going to run into someone who's going to rob you on the street. On the other hand, there are places in a densely populated city where it's more likely that that's where you're going to need a gun for self-defense. And, however many policemen are assigned, there are high crime areas. And it seems to me that what you're saying is that's probably the last place that someone's going to get a permit to carry a gun. How is that, regardless of what we think of the policy of that, how is that consistent with Heller's reasoning that the reason the Second Amendment applies a direct personal right is for self-defense?
Well, I'll say a couple of things about that. One, if you go right to history and tradition, the history was to regulate most strenuously in densely populated places. That's what fairs and markets are. So we have history, but we also have a rationale for that history, which is that where there is dense population, there is also the deterrent of lots of people, and there is the availability of law enforcement. In England, the idea was that it was the king's peace, and it was in fact an insult to the king for people to take things into their own hands.
Well, but that's not always true. It depends, obviously, in the jurisdiction and all that, but simply because a place is, well, it's paradoxical that you say a place is a high crime area, but don't worry about it because there are a lot of police around.
Well, and the other thing is that these regulations are all an effort to accommodate the right, to recognize and respect the right of self-defense while regulating it to protect the public safety. And in areas where people are packed densely together, as the questioning that just happened displays, the risks of harm from people who are packed shoulder to shoulder all having guns are much more acute than they are.
Oh, sure, and I can understand, for example, a regulation that says you can't carry a gun into, Giant Stadium, just because a lot of things are going on there, and it may not be safe to have for people to have guns. On the other hand, if the purpose of the Second Amendment is to allow people to protect themselves, that's implicated when you're in a high crime area. It's not implicated when you're out in the woods.
Well, I think it is implicated when you're out in the woods. It's just a different set of problems. I mean, you're deserted there, and and law enforcement is not available to come to your aid if something does happen. But
well, how many muggings take place in the forest?
If we
how many do you think?
I don't know, but I will tell you that our licensing officer told us that rapes and robberies happen on the deserted bike paths, and that he has some concern about that. So, I mean, I take your point that there is a different risk in the city, but there is also a different public safety consideration, and that is why the licensing officer is meant to take into account not just the risk, but also the population and the availability of law enforcement and all these considerations. I won't say that the risk, I think it's not correct to characterize the risk as atypical. The risk has to be specific to the person. What the cases say is that you can't just say, I'm afraid, because based on facts that are not specific to you. But what Mr. Nash did was convince the licensing officer that his trip to a deserted parking lot every night was sufficient.
What if it's one of these crime ways, whether it's a celebrated spate of murders carried out by a particular person? I don't know who that is, son of Sam or somebody else. Is that a good reason to? Is that a atypical reason? Is that a justification? Some random person is going around shooting people. I'd like to have a firearm, even though I didn't feel the need for one before.
Well, I think that it would have to be brought home to you in particular, to your route, to your parking lot, to your your apartment building, but something specific to you, rather than it's happening in the world at large. That's what's meant by something non-speculative.
Could I explore what that means for ordinary law-abiding citizens who feel they need to carry a firearm for self-defense. So I want you to think about people like this, people who work late at night in Manhattan. It might be somebody who cleans offices, might be a doorman at an apartment, might be a nurse or an orderly, might be somebody who washes dishes. None of these people has a criminal record. They're all law-abiding citizens. They get off work around midnight, maybe even after midnight. They have to commute home by subway, maybe by bus. When they arrive at the subway station or the bus stop, they have to walk some distance through a high crime area, and they apply for a license and they say, look, nobody has said I'm going to mug you next Thursday. However, there have been a lot of muggings in this area and I am scared to death. They do not get licenses. Is that right?
That is in general right, yes. If there's nothing particular to them, that's right.
How is that consistent with the core right to self-defense, which is protected by the Second Amendment?
Because the core right to self-defense doesn't, as this court said, doesn't allow for all to be armed for all possible confrontations in all places.
No, it doesn't, but it doesn't mean that there is the right to self-defense for celebrities and state judges and retired police officers, but pretty much not for the kind of ordinary people who have a real felt need to carry a gun to protect themselves.
Well, if that ordinary Mr. Nash had a concern about his parking lot and he got a permit, I think the extra problem in Manhattan is that your hypothetical quite appropriately entailed the subways, entailed public transit, and there are lots of people on the subways even at midnight, as I can say from personal experience, and the particular specter of a lot of armed people in an enclosed space.
There are a lot of armed people on the streets of New York and in the subways late at night right now, aren't there?
I don't know that there are a lot of armed people.
No? How many
people with illegal guns?
That's what I'm talking about.
Yeah.
How many illegal guns were seized by the New York Police Department last year? Do you have any idea?
I don't have that number, but I'm sure it's a substantial number.
But the people, all these people with illegal guns, they're on the subway, they're walking around the streets, but the ordinary, hardworking, law-abiding people I mentioned, no, they can't be armed.
Well, I think the subways when there are problems on the subways, are protected by the transit police is what happens, because the idea of proliferating arms on the subway is precisely, I think, what terrifies a great many people. The other point is that proliferating guns in a populated area where there is law enforcement jeopardizes law enforcement, because when they come, they now can't tell who's shooting, and the shooting proliferates and accelerates, and in the end, that's why there's a substantial law enforcement interest in not having widespread carrying of guns.
On the standard of particular to them, just to follow up on the other questions, why isn't it good enough to say I live in a violent area and I want to be able to defend myself?
Well, what happens in these license hearings is that a question is asked, what exactly do you mean? Because
the statistics.
It depends on how large an area you describe. You could say I live in a violent area, and that could be all of New York City, or it could be your particular neighborhood. And the closer it gets to your particular neighborhood, the better your claim is, or your block. Now, I know that one of the petitioners made an assertion about robberies on his block. I also know that there was a hearing about that, and he evidently did not convince the licensing officer that they were sufficiently recent or relevant or couldn't be dealt with adequately by his own premises license, which he would be entitled to have without any justification or proper cause at all. So what I know happens is that those claims are examined by a licensing officer. Now, this gets to to questions about discretion and whether that's effectively handled, but
Well, that's the real concern, isn't it, with any constitutional right? If it's the discretion of an individual officer, that seems inconsistent with an objective constitutional right. I mean, what if you're a runner? You say, I run a lot. And as you correctly pointed out earlier, there are a lot of serious violent crimes on running paths. It's a real problem. Is that good enough?
Probably. I mean, that's the counterpart to Nash's claim. But
probably,
if that's the question, that is not the way this case was tried. That's not the way this claim was framed. And if the question is, does the system actually operate in the way that we're describing, then this case should be remanded for a hearing to determine whether it does.
And what's the problem with the shall issue regimes from your perspective that exist in many other states, including very populous states, Florida, Illinois?
The problem with the shall issue regimes is that they multiply the number of firearms that are being carried in very densely populated places, and there is a much higher risk, without assuming any ill intent on the part of the carriers of weapons. They greatly proliferate the likelihood that mistakes will be made, fights will break out.
But has that happened in those states? I mean, can you make a comparative judgment? Because it seems like before you impose more restrictions on individual citizens and infringe their constitutional rights based on this theory, you should have to show, well, in those other states that have shall issue regimes, actually there is a lot more accidents, crime, and I don't see any real evidence of that.
Yeah, I think there is a brief from the social scientists that addresses this, but this law has been in place for over 100 years, starting at a time when the law was not as well understood in this area as it is now, and so it's a little bit anachronistic to talk about before you put this law in place, you should have evidence. But I believe there is evidence about the success that New York has had in keeping keeping gun violence down, that is attributable to the reduced number of guns that are being carried, particularly in these densely populated places. So,
General, one of the things that strikes me about this area is that on the one hand, it seems completely intuitive to me, and I think to many people. I mean, if you think about Justice Thomas's questions about less populated areas, the rural areas of New York versus the cities, I mean, it seems completely intuitive that there should be different gun regimes in New York than in Wyoming, or that there should be different gun regimes in New York City than in rural counties upstate. But it's a hard thing to match with our notion of constitutional rights generally. I mean, Mr. Clement makes a big point of this in his brief about how we would never really dream of doing that for the First Amendment or other constitutional rights. Allow that level of local flexibility that you are basically saying we should allow in this context.